Thank you for staying with us. Verdicts and votes. That's the next conversation we're having. And Professor Paul Ananaba joins us this morning. He's a senior advocate of Nigeria. Thank you so much for joining us today.
Thank you.
If you don't mind, a quick view or two on the previous conversation. Something our two guests talked about, the need for African leaders to take the lead by ensuring that they can regulate the duration of offices of sit-tight governments or heads of states on the African continent. How do you see that happening, legally or democratically speaking?
Well, we don't have that problem in Nigeria, and we're not likely to, because our constitution is very clear on tenure. So, but for some African countries, their constitution may allow them, and some of them are military in nature. But the problem is that beyond the constitution, in some countries, the level of development is and population and all that is such that the leader or the leaders can manipulate and get tenure elongation and all that. You knew when it was tried in Nigeria, you knew that it didn't work, and it won't work. The complexity of Nigeria cannot allow a sit-tight leader. So you do 2 terms maximum, and you leave. And I don't want leaders to begin to go into tenure issues. We have settled that with the constitution.
No, I mean, not in Nigeria, but I mean on the African continent, so that collaboration can be fostered.
Now in the African continent, what are you going to do? Which country in Africa is strong enough to say this is what it should be? Now the West enjoys debilitating political environment in Africa, and if you want to make Africa Africa, they will not like it, they will not support it, and you know that. So what the point is, when they have a leader where there's CBN and all that, the central bank of that country is with them. You know, the French system, it's in France, in Paris, they enjoy. The leader can go on. Even if the citizens are suffering, they get a part of it and return to you as palliative. You know, palliative is the in thing now. As aid, space it up. You'll be getting the little things, and you're happy, and they're taking your patrimony away. So the West will go for that kind of thing, but they will not allow it in their own environment.
The question is, how long will Africa continue to...
from the time Nkrumah, Patrice Lumumba, them saw it. You saw how they were, even all the way down to Jaja of Opopo and all those, or the Oba of Arami, them. They had to be exiled, and they won't come back alive. It's the same. It's just that it's a bit refined.
The question is, how long will Africa allow the exploitation to continue? But let's leave
that for some other time.
Let's leave that for some other time as we make progress to verdicts and votes. Your candidate has filed 51 grounds of appeal, and the candidate of the PDP has also filed 35 grounds of appeal. What are your expectations in that regard?
If your person files an appeal, his expectation is that he will win. So you can't file. We didn't file 1 or 2 grounds, 50. It means that if any one of them is upheld, then we are serious. But that's not what I want to discuss. We have done what we ought to do, constitutionally speaking, and we should encourage constitutional development. We should encourage resort to the Constitution rather than resort to violence. I knew that many people would have thought that, oh, there would have been boys, so yeah. No, we've gone beyond that. We should argue the issues.
But a lot of your colleagues agree that the work of the Presidential Election Petition Court was thorough, because they cited precedent and they cited also some aspects of, supporting laws, to the Constitution. And, bearing in mind also that hardly can your team or the team of the PDP present new evidence before the Supreme Court how do you hope to surmount the challenges before you?
I'm happy you said some of our colleagues have that view, and it's fine. It's a good development. At least some people can disagree with us, but we don't agree with them. And that's why we're able to find 50 grounds why we think that things ought to have been done differently. And whether we are right or wrong, we now go before the Supreme Court. So that's the point. And we need to be commended for being able, in a place where our colleagues are thinking that there's nothing, we have been able to find 50 grounds why we say, no, there are 50 reasons. You understand? And that's what I was trying to say, that law does not develop in a country when there is docility, legal docility. And what it means is that, the PEPC has said, oh, that's fine. No, the law will not develop that from that. The law will develop if we put the law to legal scrutiny and legal, except those who are saying it are saying that the Supreme Court cannot do anything. If they are saying so, we also disagree with them. This is a 5-man panel. We are now going before a 7-man panel. I'm not saying that there may not be women in it, a 7-man panel, and we have implicit confidence that the Supreme Court
So are you approaching, pardon me, are you approaching based on the optimism that, there is the need for constitutional development, but that the Supreme Court will affirm what the PEPC has done?
The point I'm making is that that's the reason why the Constitution provided for the Supreme Court. And we have now come with 1 or 2 grounds that you will say, but this doesn't seem, you only have 2 complaints. If we have multiple complaints, I'm not saying that. It means that we have also done our thorough work in scrutinizing the judgment. 2 people can be looking at the elephant, can be touching the elephant and saying different things.
Well, certainly.
The point that we are making is that from our own point of view and our resources available to us, we have been able to find 50. And we're optimistic that the Supreme Court will be dispassionate in looking at it. And the Supreme Court can go either way.
Yeah, 86 grounds in all between the PDP and the Labour Party. Are any of these grounds that were presented or not presented before the PEPC?
Those are grounds those are the arguments that can be canvassed as we go to Supreme Court. The point we are making remains that what you may look at from in us over 700 pages of judgment, where I like this analogy where we say that a businessman that drives through the street of Lagos will say, what a city, full of businesses, everything can be turned to money, business. Another person, in fact, I say, how scanty this road is. What kind of road is this? So it's a question of depth, question of interest, question of focus. We are firm and we are moving on.
Are there some of those grounds out of the 51 that you'd like to, emphasize, touch upon?
No, I wouldn't, because I am a member of the legal team, and our opponents are not here to reply. So that would be unfair.
Okay.
But you wouldn't think that a team of lawyers will just draft grounds that are not grounds.
Okay. Well, that sounds very pregnant. But there's something that you said about your expectations, being a legal practitioner, senior advocate of Nigeria, a member of the inner bar, as you say, at that. And the confidence that you expressed that this will help to strengthen the judicial processes in the country. But then speak to this. Now speak like you are not part of the entire system. There are those who feel that when I win, there is justice. When I don't win, there is no justice. How do you respond?
More people will feel that way. You know, and that's why that's why the judiciary needs to be independent, neutral, and non-partisan. And then this confidence must be rooted in the legal system, in the judiciary. And then it has a psychological restraint from doing self-help. When you win, or there's judgment in your favor, your first psychological reaction is, fine, the judiciary is the best. And that's why, that is the reason behind the appellate process. It is in the appellate process that you begin to see the other man that lost will be saying, this judgment you have is a fluke, either because of legal grounds or merit or some other grounds. Now, mostly the politicians, they are more happier when they win. And that's why they will tell you, go to court.
Isn't the lawyer also happy?
The lawyers may be happy because if you
will be proud.
Maybe I speak advisedly. You know, if you are doing a case as a lawyer, you ought to have done case analysis. If you bring a brief to my firm, we will subject it to case analysis, so we have an idea whether we will win or not. Because the law is, the judicial precedent is there. Even though most of those precedents are no longer reliable in our legal system today. You can get a decision this way today, and it goes this way. But in a classical legal system, in the Nigerian space, you will find that you can determine with certainty what the principles of law, what the Supreme Court has said over these points clearly.
Okay, Prof, I'd like you to weigh in on this one. Well, I'll toe the path of Ayo as an independent individual of the inner bar.
Yeah.
It seems like the candidate of the PDP is very firm in his resolve to upturn the case at home, and then he has approached a U.S. court and asked it to compel Chicago State University to produce documents, information, or objects on the president to permit inspection of same. And it appears that the U.S. court has ruled now compelling the State University to do likewise.
Yeah.
How does that impact on the case at home?
I'm not in the PDP legal team. You see, the law is, at the Supreme Court, the court it looks at justice. They look at justice. They can overrule themselves. They can take any procedure. There are provisions in the Supreme Court rules and the Supreme Court Act that allows them to even discard everything, get to the root of what is just, and take a decision.
But even at that,
Yes.
Even if the PDP candidate and its party get fresh evidence, they can't tender it before the Supreme Court, can't they?
Can they?
I'm not going to take arguments here, but I know that that's why I told you that you cannot buy the Supreme Court. You cannot, and our Supreme Court has done well over the years.
Okay.
Well, they will look at the matters as they come. You cannot wake up and then say, "Oh, the Supreme Court can do this, cannot do this." No, you are not talking about Court of Appeal or the High Court. You're talking about the Supreme Court. That's why they're supreme. They're supreme because they will look at. They can raise some issues on their own and say, "What about this?"
So Then speak to us before we go to another issue. How do you react, or how does it sound to you when some legal practitioners impugn the judiciary, particularly the integrity of court judgments, or even the Supreme Court?
It's sad. There's that latitude to analyze the judgment of a court, be it the High Court, Court of Appeal, or the Supreme Court. But impugning the court or abusing the court or the judges is wrong.
Is there a system within your industry?
No. When a lawyer does that, he will be subjected to discipline. The point we have is, in our system, people hardly come forward to give evidence or to report formally. You see, your due process. Often we don't insist on due process. And for example, if there's an issue like that and someone wants to ensure that the due process is followed, the next minute, one or two people are calling, you will be calling, please leave now, people from your community and all that. That's it. But if we, as a country, begin to emphasize, even as a profession, that there should be sanction, the due process must be followed to the letter, some of these things will be curtailed.
Okay. Now, you talked about the integrity of the judiciary and the supremacy of the Supreme Court. But then there are also those who are pointing at the role of the legislature and the sanctity of the legislative chambers. Perhaps that's the reason that Senator Bokachua went to court to stop ICPC and the DSS from investigating him over the indicting comments that he made during the valedictory session of the 9th National Assembly. Of course, the court has taken a decision on that, but then what does that say about the sanctity of the floor of the National Assembly? Does that mean?
I think it's often described as the hallowed chambers. But you know that hallowed chambers, quite a large number of them are lawyers. And that hallowed chambers is populated by professional politicians. I hope you know that. You can ask someone, what's your profession in Nigeria? He said, I'm a politician.
I'm here to see complimentary card.
I'm a politician. So when you have such situation, politics is a game of interest and not necessarily the hallowedness of the chambers. Now, when politics is immediately after the election that brought them there, they are thinking of the next election. It takes us back to the point that we have not gotten certain things right in our political system. The issue of political ideology being seriously taken has not taken root. Now, a Democrat is a Democrat. A Republican is a Republican. And that checks cross-carpeting unnecessarily. We're not patient. We only have political parties in name. You see a PDP person going to APC tomorrow, going to NNPP, going to ABGA, going to Labour Party. Those in Labour Party, for example, are they Labour principled? Are you with me? Yeah. If they say do they accept Labour ideology? Those in PDP, are they Democrats? You get the point.
Yeah.
As long as we don't have that, even if you go to the Legislative Assembly, they are not talking based on the ideology and manifesto. They are talking based on, in this constituency, this is the party that will win. We cross over. And even the laws made to checkmate that under the Electoral Act,
Well, you're not yet speaking, Prof, to the issue really, because there is that belief. Just before we go to Abuja, there is that belief that whatever is said on the floor of the National Assembly
is gospel,
is sanctity, and then so now
I would rather ascribe that more to the hallowed chambers of the courts than to a gathering of politicians.
So you believe that their office as politicians is, first of all, more profound or more visible than their office as
senators.
As senators.
Which it's just like 6.5. What are you? Which one? It's the same individuals you're talking about.
Okay.
Well, before we go to Abuja, Ayo, pardon me, Prof, weighing on this one, Justice Ekwo also ruled that the plaintiff, that's Senator Bolkachua, his speech on the floor is a confession of illegal acts, and therefore cannot be protected by Section 39, subsection 1 of the Constitution. So what aspect of the law has he breached there, and what's the punitive measure that it attracts? And also, more importantly, who should be taking a cue from the ruling of Justice Ekwo?
The distinguished judge has made pronouncements, and you remember that action was just to stop security agencies from going in and bringing out facts and evidence based on which there may be prosecution or there may not be. So this idea, I'm happy that judges are speaking up. In the past, you find a politician obtaining an order, stopping security agencies from probing and all that. That's not correct. The security agencies are in the executive. They should be allowed to do their work. They also should not witch hunt. They should build the integrity of, yes, they are doing a legitimate thing.
Okay. Nyata.
Well, Professor Ananaba, I was going to ask this question. So let me just read something here and then put the question. Leadership is the art of giving people a platform for spreading ideas that work. You said something about the issue of political ideology would seem not to be there. So we have the three arms of government, the executive, legislature, and the judiciary. And it looks as if the judiciary here is the leader, has become the leader of our political space, so to speak, helping to carve out a pathway for our political life as a nation. Sometime in Imo State, Governor Hope Uzodimma was fourth, and he went to the court and he was sworn in as governor. There are those who are wondering, can the judiciary be that leader that will set the pathway for our political life indeed, putting forth ideas that work for the good of the nation? Do you think that can happen? That's my question.
There is a difference between what is and what ought to be. And I think this issue of what is and ought is what is playing out. The citizens believe that it ought to be this way. And the courts sometimes say, no, this is what it is. Let's not continue to vilify the courts. Once the courts are no longer there, where will we go to? Will you run to the legislature or to the executive? So that is not to say that the judiciary has run a perfect process all through. There have been issues of concern. There have been judgments that are controversial, and it's so all over the world. But ours, we have more, because in one election cycle, you'll be getting up to 600, 700, 800 cases in the form of petitions, other pre or post-election issues. It puts so much weight on the judiciary. And it's just like when you're playing football, if out of the 90 minutes, 80 minutes is played within the half of a particular team, they either concede a goal or they have penalty and all that. That's what you see. Let us start pulling back a bit. let's take these electoral issues. Number one, we need electoral reforms, and I'll propose a few of them. If you don't want the judiciary to be so overloaded, before I make that proposition, look at our Court of Appeals. How many election appeals are they going to hear? The regular court cases are also there. What do you want them to do? They are human beings. The pressure, they will not have all the time to look at matters. Look at the Supreme Court. How many cases does the U.S. Supreme Court take in a year? But now, they are going to take the presidential, most of the governorships, and all that. If you add that to the number of Supreme Court cases we have today, it's baffling. Cases filed in 2010 have not been heard at the Supreme Court, many of them. It has not got to their turn. That's 13 years. So that's the problem. Let us, who are Nigerians, who are politicians, begin to help the system also, reduce the burden. The legislature there should be a thorough amendment of the Electoral Act. The Electoral Act still is far away from what I think will bring that kind of way that you now have fewer litigation and thorough determination. I'll give you an example of what I think should happen. I believe that we should move the onus of proof in electoral cases to INEC. That singular act will reduce election petitions by 50%. What does it mean? INEC conducts election. And after the election, it is the man who lost that will now go to tribunal. And from the decisions you are seeing now, everything he will do must be within 21 days in Nigeria. If he also wants INEC to come and give evidence in any part of it, he must bring that INEC person. He will swear to affidavit with the witness statement within 21 days. You know it is not correct. It won't work.
I guess it sounds like you are calling for an adjustment of the laws.
Yeah, the amendment, yes.
Okay, all right.
So if we would do that and say, okay, INEC, 7 days after every election, there must be soft copies of every process. Nobody comes to you to say, leave, grant us leave to go and inspect or not. You are neutral.
Okay.
You are not a party. In our elections, INEC should no longer be a respondent. INEC should be an independent party.
Well,
you call INEC, they bring all the processes, so that within 7 days, each party will look at it and see whether there is anything to compare. We can finish our election petitions all the way to the Supreme Court within 5-6 weeks.
Wow, interesting. Well, we have to thank you very much, Prof, for this morning. It's been very, very insightful. Professor Paul Ananaba is a senior advocate of Nigeria. Thank you so much for your thoughts this morning.